This is what the place looked like when the guards and the bailiffs left.
Do your job. Look at this. Look at this. He will be responsible. Give me a hand. That's one of your own.
That's one of your fucking own. That's a disgrace. You should be fucking ashamed of yourselves.
Very welcome to the state we're in. You have been looking at a couple of video clips there. The first one is from an attempted eviction in Prussia Street that took place recently in Dublin. And the second clip is from the eviction of the McGann family from their home in Strokestown in December 2018. And then there is a statement from the Irish Council for Civil Liberties that says that there is no legal basis for Garda participation or facilitation of evictions. I'm going to talk now to Margaret Hanrahan, who was evicted recently from her apartment in Dublin. Margaret, you're very welcome.
Thank you, Anna.
Margaret, maybe you'd begin by just telling our viewers a little bit about the background to your eviction.
My eviction took place there at the end of September this year. And it all to do with I've been a tenant in the premises in 21 Little Mary Street for 10 years. And this is to do with an eviction order, a possession order that started in 2008, which by the way, none of the tenants knew this ever existed. Now, to be very clear, some of the tenants are in existence in some of those premises for the last 17 years with a full valid and legal agreement, a tenancy agreement stamped and registered in the tenancy board, which has no legal benefit at all to them now in our case. So what happened was there was an order made in the court in 2020 for a committal order, which none of the tenants knew anything about because the papers came in not addressed to anybody. Bundles of papers come into the properties. There's a 7-flat property in one, there's a 5-flat property in the other, 5 flats in the other property. So loads of paperwork came in, but it was addressed to nobody in particular, not even addressed to the number of the flats. So nobody bothered to open it, it had nothing to do with them. So eventually, anyway, there was an order made in our absence to have us committed. Brought to the court.
Margaret, can I interrupt you there? For people who don't know what to have you committed means, that means that if you don't leave the premises immediately or by a certain time, that you will be arrested, brought before the court and possibly jailed. Am I correct in saying that?
That is correct. Now, we were only to find out about this order from somebody in the court that day as an observer, but we as tenants knew nothing about it. So the order was made in our absence, and this is the danger. The order is made in your absence. You don't have to be actually in the court. So to somebody, you know, that was just an ordinary person that was in the court and must have contacted somebody and said, lads, you're in trouble. So we didn't know anything about the trouble, but the reality was that the order was made in our absence, and then the guards were sent a notice to have us arrested. And the guards' job was that we would voluntarily go back into the court, or if we didn't, they would arrest us and bring us to the court. And then eventually, if we didn't leave the premises, they would jail us. That was the order that was made. And this is called a new process. Before you'd be going to the court, you get your possession order, you get time to leave, to be a stay on it. But now they're going into the court, the banks, barristers, senior counsel now at this stage, Rossa Fanning, senior counsel for the bank. Now, if you remember, the bank starts off at a bank that would say like IIB Bank, then it goes to KBC, then it goes to Pepper, then it goes to some Belchany. So we're dealing with lots of people the tenants know absolutely nothing about. This is all history, and people are talking to us about, oh, it was owned by this bank. We hadn't a clue. None of us, not one of. And the sad thing about it in one of the other houses was most of the people had no English. Even if they did get the summons, they couldn't read it. But Judge Reynolds made it very clear. She was not taking that in consideration at all. We had ample time. So if people think they're going to get sympathy in the court, they can forget about it, because ample time means now. You get the summons this morning and you get ample time to be in court in the next day. See, with a mandatory interlocutory injunction, it means they can get to be brought into court at a whip. They could be put into court, issue the summons today and be in court in the next few days. That's what mandatory is all about. It's so that important.
So, Margaret, you know, I have read the judgment in your case, and I believe that it sets a legal precedence. Tell me a little bit about that.
Now, this precedent is there now forevermore, so far as that the majority of people who have got the old possession order, some of them haven't got on, sitting in their house since 2008, and nothing has been done. But with this new mandatory order, that possession order can be brought into court tomorrow morning and be made legal. And the legal side of it is, if you don't attend to what they're looking for on the mandatory, on the possession order, they will have made all the right things in the court, saying that they want a possession, they have a possession order, they want to enforce. It's an enforcement of a possession order. But enforcement of the possession order years and years ago was with the sheriff. To go to the sheriff, he'd go down, he'd see what he could do, and he'd get assistance. But he was the man that's in charge. But with these new orders, it's this crowd now, like called KTEC Security, they come out now. These are all KTEC Security, the security team. But they come down then, we don't know who they are, what they are, and they will tell you to clear out if they get to you. But the guards then, the guards have to come as well, but the guards then have the order to pick us up if we don't leave.
So what I'm hearing from you now, Margaret, is that people have remained on in their houses. There were judgments made on the properties back in 2008, 2009, 2010. In your particular case, the judgment was in 2008. And of course, property was at an all-time low. And now with the massive increase in the value of properties, the banks are now moving in at the moment en masse to, I suppose, for want of a better word, they're moving in to execute those judgments. And your particular case, the judgment in your particular case has set a legal precedent whereby it doesn't have to go through what was the normal channels in the old days, like we saw there in the eviction of the McGann family in Strokestown. The new precedent now is that there will be a mandatory interlocutory injunction, which means that people will only have a couple of days to get out of the property. And if they don't move, the guards now have new powers to come in and arrest the tenants or the leaseholder or the person, you know, the mortgage holder. Am I right in saying that?
Yes, the security team will come in and they'll not arrest you, they'll drag you out. There's no question of what they'll do to you. You look at what happened above the last eviction there on the street. They will do exactly to in any private house. And this is where people need to go back into to see when did this possession order come into their houses. They have no protection now. And there's just to be very clear, there's a new judgment that's been issued in the last few days on the basis of our judgment. This mandatory order has been brought into the court to put the tenants out as well. There was a woman with a couple of children. She got no sympathy whatsoever from the court. All they said was that she had the benefit of the house since 2008, and why should she worry about being thrown out of it now?
So, Margaret, this is really worrying, but for me it's not surprising because I interviewed you last year and you said that there was a tsunami of evictions coming down the line, and it looks now as if what you said then is starting to happen now. So from what you're saying is that there is a considerable number of people now in great danger of losing their homes in the near future.
Absolutely. And a lot of these people never appealed the order. And you see, once you didn't appeal the order, you have no protection at all. And because people have thought, well, it's gone away, they haven't contacted me for so many years. And even in some cases where the order is out of date, the judge just goes in and stamps it up and says, well, we're going to perfect it today. So people thought because maybe gone 2008 has gone 12 years. It's not, because in the circuit court, your order is stamped up every year without you knowing it. It makes the order valid. And what we see, before we had groups, Anna, where we could go and talk to people about, I don't know of any group now that's helping anybody. And we were never given legal advice, but this is very serious advice. And I'm saying today is you must go back to your order. The time is coming. The banks have had you now as a caretaker for that house, and now to see the value of the house. So out the door you will go. And this is not a threat, this is a fact. Now the central bank have issued some kind of a propaganda the other day where the bank should make contact and maybe leave the tenants in it. Well, I'll tell you an exact story where start mortgages. I have a woman in her 80 years of age. We owe 40,000, and if this is, I can show it's in Denise Court. We owe 40,000 on the house, and we have gathered 35. Start mortgages won't release the mortgage. They said she can sell the house for 5,000 euros. And this is in Naas Court. And all the judge has said is his hands are tied, he can do nothing. We're talking 5,000.
This is absolutely horrendous. So what you're telling me, Margaret, is that people that have got into difficulties with their mortgage, and I suppose that extends to business owners and it extends to farmers as well. People that have got into difficulties are now possibly facing homelessness, and people that are tenants in properties that are subject of repossession orders. In your particular case, many of the tenants had a tenancy that was rubber stamped by the tenancy board, and it wasn't worth the paper that they're written on. Just on that particular point, Margaret, in your particular judgment, what does the judgment have to say about landlords letting out properties in relation to the banks?
This is very, very serious. Once you have a mortgage, and unless the bank agreed to allow the owner of that property, giving him a right to let in tenants in there in the first place, you have no rights at all. And there's a part in the mortgage agreement. I mean, that's a 32-page document, which very few people read, very few people understand. But one of the clauses in it, you must get the consent of the bank to allow tenants to be in there, even though you have borrowed the money to buy for a buy-to-let, and the bank are well aware that you're letting in tenants, but the clause still remains and nobody reads it. So once you go into the court, you have broken the landlord has broken the condition. Now, I think I said this and I got a slating over it. I said on one of your problems, you really need to see the mortgage on the property to know has the landlord a right to let you in there in the first place, because in most cases he hasn't. So you have no protection, and that's outside of the RTB board, because the RTB board, the bank has they precede anything to do with the RTB board, because the banks have all rights.
Okay, so Margaret, in your particular case, and just to repeat what you have said, the judgment in your particular case has set a precedent whereby the banks can now go into the court to get a mandatory interlocutory injunction to remove the tenants or the mortgagee from the property in a very, very short space of time. If people don't comply with this court order, the guards then have the power to go in and arrest the people involved, and it can all happen very, very speedily. Now, is there any hope, Margaret, of that particular judgment being appealed?
Yes, because we were not served properly, and in fairness, our barristers, our solicitors have made a decision to appeal the order, because they have made it very clear in the judgment of Judge Sanfi that he didn't deal with the procedural matters. Now, these are very particular things. So they also brought to the attention of the court today that the judgment was being read out, and they advised the judge in the situation, Judge Sanfi, that they weren't pleased with the outcome, but he said, what will be, will be. And that's exactly, so thank God through the grace of God, I suppose, that the order has been appealed, and hopefully that the order, that what we are saddled with and the eviction will be overturned. And just to be clear, if you leave any property in it, now, so a lot of the tenants in my case couldn't take their bits of bed, whatever they had, they had nowhere to go. So that your contents that are sold or thrown to the dump, you get so many days to come in and remove your contents. And if you're not back within 3 days to do that, they destroy them or sell them.
That is really, really worrisome. So, Margaret, we'll catch up with you later on when your particular judgment is appealed to the Court of Appeal, and we'll watch that space very, very carefully. So, Margaret, thank you so much for joining us today. Before you go, perhaps you might have a word of advice for anybody that now finds themselves in difficulties with the banks.
Well, my advice would be to find someone that has been through the system, and by God, there's so many has been through the system. Don't be ashamed to say you have a possession order, because that's the killer. Shame has put you where you are and has not progressed any further. Days upon days, you'll find judgments. I teach you how to look at judgments, but please talk to somebody. That's my advice, is just talk to somebody. And maybe visit the courts and see what's going on. Don't be ashamed to go into the courts, because you'll see the whole process there. And usually in the courts, there's somebody there that will identify with you, or you identify them, and go over and say to them, look, I'm in that position. They're a black stranger. You can tell them your story. It won't be repeated. And you're in a safe place. And maybe they can help you, but at least you have someone that's the same as yourself. But
right.
Do not sit at home.
Right. Thank you so much, Margaret.
Thank you, Anna. Thank you. God bless.
To those of you who have been watching, I thank you, and I ask you please to share this video. Compass Media is a new news platform set up by myself and Dr. Finbar Markey. We'll never ask you for money, but we do ask you please to share our videos and to please subscribe to our Facebook page and our YouTube channel. We're also available on mcompassmedia.com. Thank you so much for watching, and until we meet again, Bannock de Arif Galer.